Hey, everybody. Today we're going to talk about how to properly name the beneficiaries under your retirement and life insurance. So, first, let's talk about one of the most common and costly mistakes in estate planning, which is that naming. It's not just about who you name, it's about how that choice affects the protections that you may have and possible taxes. I'm Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey. We provide peace of mind to families through our high client value services. If you need our assistance in either creating your estate plan or administering one after the loss of a loved one, we'd be happy to help. You can reach us for a free consultation at yourplanningattorney.com. And speaking of value, we are always here to educate as well. So if you could, ask questions and don't forget to share. So together we can help some folks along the way. So first off, life insurance, retirement, including IRAs, 401ks, they do pass directly to your named beneficiaries, which means it does avoid the probate process as long as you have named either an individual or a trust, okay? If you don't have either an individual or trust, it does default to your estate, which means it will go through the probate process. So make sure that doesn't happen. But naming an individual does not necessarily mean you're protecting your beneficiaries from their own creditors or potential divorces. So how do we go about this? You can name your trust if it is a part of your plan. Your estate plan includes a trust. You can designate it as the beneficiary of either your retirement or your life insurance. Now, of course, naming an individual can be quick and simple, but it really just falls short of all the things that you can provide to your loved ones. Now, naming the trust does and can, if drafted properly, can insulate those monies that your beneficiaries, your family will receive from creditors, including potential divorce. And it can control also, if it needs to, the timing or the conditions of the distribution of the funds. Now, you do have to consider also that when you name a trust, and a lot of people, even those within the industry, such as financial advisors or accountants or what have you, who are maybe not as familiar with the intricacies of trusts, as detailed as an estate planning attorney would be, they get a little wary when they see a trust as a beneficiary because their concern is that it's going to speed the distribution of that retirement, which means typically bigger taxes for the family. But that's not if it's drafted properly. So it is really important that you make sure that you're working with a professional who knows how to get it done the right way. Because then not only are you not hindering the family for tax consequences, but then you're also adding some protections and control to the distributions of those assets that would normally, again, avoid the probate process, but in now a better way. So make sure you're coordinating your beneficiary designations with your trust and overall estate plan, and that your trust itself is written to qualify basically those retirement accounts. It's called, I'm going to give you a quick phrase that you could use with your professional. If you're not in New York or New Jersey working with us, it's called a see-through trust. You want a see-through trust so that the distributions will be considered not as a trust distribution, but really to the ultimate individual. Okay? Just remember, a few simple updates today can protect your family from kind of some major headaches later and give them added benefits, protections, and all the things that you would want for them. If you are, of course, in New York or New Jersey, we'd be happy to help you, and your first conversation with us is free. Just go to yourplanningattorney.com. We hope you've learned something new here today. Don't forget to share, and as always, take care.